Schools NorthEast is an inclusive network led by head teachers. Its core purpose is to support the enhancement of education for all pupils of the 1,250 NorthEast schools. Schools NorthEast is always looking for ways to support schools in the region, and we understand the time pressures and financial constraints that sometimes come with attending a physical event. So, to try and support both of these factors, we have introduced a webinar program to try and get the information directly to you. A number of schools have requested support around the upcoming changes to the General Data Protection Regulation. This is why we have worked together with Muckle to bring this information to you with this virtual event. However, we do also recognise the power of a face-to-face event. So for this reason, we are holding a second physical event next week, which is the GDPR for Education Organisations, an Introduction to Compliance. So before we get started, I would like to inform you all that this is Schools NorthEast's first ever webinar. Please be sympathetic, as there may be a couple of speed bumps along the way, but it's only going to improve and get better from here. I would now like to introduce you to our presenters so that we can get straight onto the content. Our guest speaker is Stephanie Coulson, Associate Solicitor from Muckle LLP. Stephanie specialises in data protection and regularly advises clients from all sectors. She applies her extensive knowledge and experience across a variety of sectors, in particular charity and education. Today, Stephanie will discuss the top 10 facts and top 10 tips so that you are ready to start your journey to general data protection and regulation compliance. So, I will now hand over to Stephanie.
Thank you very much, Sam, and I'd like to thank everybody who has signed into the webinar for joining us this afternoon. As Sam has mentioned, today we're going to be looking at the top 10 facts and top 10 tips for the GDPR. So what better way to start off than by doing a poll? So I'd like to hand back over to Sam so that she can launch the poll for us.
Thanks, Stephanie. So as Steph said, we're now going to have a poll question. This is going to pop right up on your screen. So the question is, do you have any of the following policies and/or procedures in place?
Sorry, Sam, I think the first poll question we've got is actually to see if anybody started their preparations for the GDPR. So apologies for any confusion, everyone.
Yes, apologies there, that's my fault. Like I said, there is going to be a few speed bumps on the way as this is the first webinar. So once again, we're starting a poll. If you haven't answered yet, you can answer now. So the question is, have you started your preparations for the GDPR? You can either answer yes or no. So we're just going to wait for a couple more of you to answer. If you haven't answered yet, please do so now. And then we're going to share the results with everybody and I will hand back over to Stephanie. So we'll just wait one more minute. So I'm now going to share these results and we're going to hand back over to Stephanie. There you go.
I was hoping that you were all going to say yes, and then we could all just go home and not have to start doing anything else on the webinar. But it is good to see that you've answered honestly if this isn't something you've started to think about. So hopefully, as we run through the next part of this webinar, you'll be able to get some facts about the GDPR and also look at some tips so that I can assist you with going forward. So before you skip on to fact 2, let's take a look at fact number 1. So the General Data Protection Regulation is the title of the regulation that is now going to be replacing the Data Protection Act. It's already been agreed upon, the wording has been finalised, and we'll look a little bit later at your date for compliance. The boring lawyer bit in me has to tell you that it's a piece of European legislation, and because it's a regulation, we don't need to implement any other statute into the UK regime in order to implement it in the UK. It has what we call direct effect. A slight caveat is that there are a few derogations, which are specific areas that each member state can decide upon themselves. And the first one of those we'll have a look at in one of my other facts and tips. So you were probably all thinking I was going a bit crazy there when I was talking to you about Europe. But fact number 2 is in relation to Brexit. Despite the fact that we will be leaving the European Union, we have had confirmation both from the UK government and from the Information Commissioner's Office, which is the regulator for data protection in the UK, that they will be implementing the GDPR in any event. And the data protection bill is currently working its way through its first reading in Parliament. So sadly, for those of you who thought you might be able to get away without having to worry about this, I'm afraid it's still going to be in force. Fact number 3 is the actual extraterritorial reach of the GDPR. So at the moment, the Data Protection Act will just apply to organisations who are based in the UK. But actually, the General Data Protection Regulation will apply to activities of controllers or processors, and I'll talk a bit about what those are later, who are established in the European Union, but it also applies to activities of controllers and processors who process data in the European Union, even if they're located outside. So this means that those big global giants like Apple and Amazon and Facebook will also have to comply with the provisions. So here it is, fact number 4, the key date for your diaries. You must be compliant with the General Data Protection Regulation by the 25th of May 2018. As I mentioned, the law has already been agreed, with the exception of some derogations, and we are now in what's called the period of implementation. There is some useful guidance as well as this webinar today that I will talk to you about later, which can also help you on your journey to compliance. So this is the one that worries most people. There's been quite a lot of scaremongering around it, but fact number 5 is about the fines. So at the moment, under the Data Protection Act 1998, the Information Commissioner's Office has got the ability to fine up to £500,000. And actually, to date, the largest fine they have levied is £400,000, and that was for the data breach by TalkTalk late last year. Under the GDPR, however, things will be hotting up and the fines will be increasing significantly. There will be a 2-tier fining system. Tier 1 is a fine of up to €10 million or 2% of your global annual turnover, whichever is the higher. And Tier 2 is up to €20 million or 4% of your global annual turnover, whichever is higher. So just to give you an example of what kinds of breaches fall within those 2 tiers, for the less serious breaches, we're looking at things like not keeping adequate records of consent for marketing purposes. And at Tier 2, it's breaching one of the actual data protection principles, for example, not having a legal basis on which you can process personal data. Fact number 6 is in relation to data controllers. Now, before I go any further, I did promise I'd tell you what these are. I think that everybody in the audience today will work for an organisation that is a data controller. This is the catchy definition from the Data Protection Act: a natural or legal person, public authority, agency, or other body which either alone or jointly with others determines the purposes and means of the processing of personal data. Well, it's quite wordy, isn't it? Effectively, it's the organisation that collects people's information and decides what they're going to do with it. Under the GDPR, there are still a lot of direct obligations on the data controllers, but you won't have to notify the ICO anymore, and you won't have to pay your £35 fee to be on the register of data controllers. So there are some good news items in the GDPR. You will need, as a data controller, to comply with the data protection principles. These are set out in the Data Protection Act currently and will be mirrored in the General Data Protection Regulation with one additional new principle. So the current principles, which are mirrored in the GDPR, are that you have to have a fair and lawful basis on which to process data. The second one is that you cannot keep data for longer than is necessary. The third one is that you need to keep it secure. Fourth one is that you can only have the data that you need for the purposes for which you will be processing. You have to keep it accurate. You should adopt a policy of data minimization, so if you don't need it, don't collect it. And you can only use data for the purpose for which you've collected it. So if you collect it for one reason, you can't use it for another one. And then the new principle is accountability. And we'll talk about that at a few different stages in this webinar. But essentially, you will need to be able to demonstrate to the ICO, if they came in to ask you some questions about your compliance, that you are compliant with the GDPR and prove it using policies and procedures, using written records and your file of compliance. You will also, as a data controller, be required to notify serious breaches of the Data Protection Act to the Information Commissioner's Office within 72 hours of awareness. Now, currently, there is no obligation to actually report breaches, albeit it is recommended in serious cases. And I've also suggested a couple of actions to take. First one, listen to the top 10 tips, but also make sure that all of your communications that you make to your students and your staff and parents when you collect data are correct and updated in line with GDPR, and have a look at the contracts you have in place with any data processors. Fact 7 is in relation to data processors. Again, let's have a look at what they are. So the definition is a natural or legal person, public authority, agency, or any other body which processes personal data on behalf of the controller. Well, that doesn't seem to make very much sense, does it? Effectively, a data controller collects information, and sometimes they get other organizations to do things with it for them. The best way to look at this, and the best example to use, is if you outsource your payroll to another provider. You will ask them to take the information about your employees and use it in order to run payroll. They will only use it for that purpose and only do it in line with your instructions. A big change under the GDPR is that there will be obligations direct on the data processors. At the moment, they have no statutory obligations at all. So you may find that if you have data processors who carry out activities on behalf of your organization, they'll be getting in touch to see if they can renegotiate their contract. I'm not going to give you a full definition of what processing means, because effectively it means doing anything with personal data. Collecting it, holding it, storing it, even deleting it can count as processing. And the obligations on data processors are not to comply with the actual principles themselves, but they may be required to have data protection officers, which we'll talk about later. They will have to comply with the requirements on security of personal data. And as a data controller, you will have to have a written contract in place with any data processor that you have. So have a think about whether you have, for example, any sports coaches that are independently employed who come into your organization on a weekly basis, for example, who get details in relation to the students. You need to make sure you have a written contract in place with them, and there are various matters that have to be covered in that contract. The next fact is about data subjects. So as with the last two, I'll tell you what that means, but luckily this is the easiest one to define. It's you and I. It's the living individual person whose data is being collected and processed. Under the GDPR, there'll be some changes in relation to the rights that a data subject has. The first one I'll talk about is the subject access request. Now, I'm not sure if any of you have had to deal with subject access requests in your educational organization, but they are tiring, they are difficult, and they are very time consuming. At the moment, if you've had to deal with one of these, you will know that you can charge a hefty fee of £10 and that you have to respond within 40 calendar days. Under the GDPR, you can't charge that £10 anymore, so I'm not sure quite how you'll be able to pay for the services of your individual staff who'll be helping you with the process, and you'll only have 1 calendar month to respond, so it's going to make it even trickier. I'll touch briefly on the other rights here, but I think the subject access request is the one that'll be most important to this audience. So we have the right of data portability. This is effectively to prevent companies from holding your data to ransom. So on a personal note, if you've got some photographs, for example, on Facebook, and you want to be able to download them from there and move them to a different social media app, then you will be able to do so. The next one is the right to object to profiling. Now this is if you are scrolling through your Facebook account over lunchtime or after work, and suddenly things pop up on the screen that look very familiar to you. For example, would you like to buy that pair of shoes that you had a look at yesterday? Or do you want to go and book that hotel room that you were looking at? Your phone is watching you and it is profiling you, and people from the 25th of May next year will be able to object to that profiling. The last one is the right to be forgotten. made famous by a case about 2 years ago now, but this will give individuals the right to write to you and say, I would like you to forget about me and delete all my personal data. Very important thing to note is that this does not override any statutory obligations that you have to retain data, and in fact, many of your insurance policies as well will require that you maintain data for a certain amount of time, either in relation to your students or in relation to your employees. Fact number 9 is around data protection officers. This is a new position that's being developed by the GDPR, and there will be certain organisations, for example public authorities, and any organisations whose core activities are processing, which requires regular and systematic monitoring of data subjects on a large scale, or where the core activities is processing a lot of sensitive personal data, or soon to be known special categories. That includes, for example, health records and political opinions, race, religious beliefs, etc. The role of a data protection officer, if you are required to have one, is to inform and advise the data controller or data processor and its employees who are processing personal data of their obligations under the GDPR. They then have to monitor compliance with the GDPR and make sure they raise awareness of staff. They provide advice, cooperate with the ICO, and act as a contact point for the ICO. They have to be independent, so it can't be your head of IT and it probably can't be your head of HR. And they have to be experts. But the good news for those of you out there who are thinking of a career change, it's a protected role. You cannot be fired simply for telling your organisation you work for that they can't do something because of data protection. There is some helpful Article 29 Working Party guidance on data protection officers, should you wish to know any more. Our last fact is in relation to children, which I think will be absolutely key for the audience today. So at what age does a child become an adult for the purposes of data protection? I would love to be able to ask you all if you could take a guess, but the answer at the moment is that there's no set age. To give you an indication, in Scotland the age is 12, and the Data Protection Act at the moment says that it depends upon the maturity of that individual and whether or not you believe they can understand the concept of their own personal data. Now, I don't know about you out there, but if I think about how young children are now on telephones and on the internet and sharing their personal data in all sorts of ways, I think that age does get lower and lower each year. Under the GDPR, there is no set age either, but each member state will be able to choose an age. This is one of the national derogations I spoke about, provided such age falls between 13 and 16. I'm not a betting person, but I would say I believe it'll be closer to 13 than 16, judging by the way that we have handled it since the Data Protection Act. A little note as well, if any of you use what's called information society services, which actually is basically any services that are delivered over the internet. So if you've got any e-learning providers where children sign up online to enter into different exercises, you will have to have parental consent or guardian consent to process the personal data of children for those services. So those are my top 10 facts in relation to the GDPR. I hope you found that a useful whistle-stop tour. And now we'll have a little look at my top 10 tips. Now, it seems strange for someone who works as a lawyer in private practice to be plugging a different organisation, but my first tip genuinely is the Information Commissioner's Office. They are the regulator in England and Wales for data protection matters, and they have an entire section on their website, the link's at the bottom of the slide there, for data protection reform. There is a lot of guidance available and some that is soon to be presented on the website. And it has links to the Article 29 Working Party that I mentioned before. Elizabeth Denham, who is the current Information Commissioner, has also just started what she calls her myth-busting blog. So this is a very accessible blog that you can also find on the website that tells you not to be quite as worried about data protection changes as perhaps the media would lead you to believe. They've launched a new online chat, which means you can ask questions on a chat system with them, and then they will send you a copy of the transcript, and they've got a helpline that you can call between normal office hours. I definitely recommend having a look on there to help you in your journey towards data protection compliance. My next tip is in relation to data mapping. This really, I believe, is the first starting point for your organisation for those of you who've not yet started your journey to compliance. You really need to understand what data you hold and the journey that that data takes through your organisation. The best way to do this is to split the type of individuals into different categories and then ask yourself the 5 W's. You will probably have staff data, you will have data on students or your pupils, you'll have data on parents and guardians, and you'll have data on suppliers. Now, you need to have a legal basis to hold each piece of personal data you hold, but that might be different depending upon the category. For example, for your staff, it'll be so that you can perform your contractual obligation of employing them. So I couldn't very well say to my employer, I don't want you to hold any of my personal data, because they then wouldn't be able to pay me, which would be quite troubling. In relation to your students and your pupils, there are other bases for processing data that you can rely on. So split the categories of individuals and then ask yourself why you hold it, what data you collect, whose data it is, when you collect it, where you store it, and that will be both electronic and hard copy, who you give it to, and when you delete it. Tip 3, when you've completed your data map, which will be quite a difficult exercise and do when you're data mapping, also consult other areas of your organisation. The next thing to do is get rid of everything you don't need. It's basically like clearing out your house and then going to the tip. So what you need to do at that stage is consider retention. How long do you need certain data for? And do you keep things for longer than you actually need? So some of the clients I've talked to end up keeping their old employee data for 30 years after someone's left their employment. You need to ask yourself why. If you can justify it, for example, by statutory reason or otherwise, then yes, you can keep it for that amount of time. But it's important to make sure your policies on retention are up to date, so that if someone asks a question as to how long you keep their data, you can point them to that direction. I'm now going to hand over to Sam to launch the next poll.
Thanks, Steph. So as Steph just said, we're now going to take another poll. So once again, this is going to pop up onto your screen. It should be popping up right now. So the question is, do you have any of the following policies and or procedures in place? So you can choose one or more of these answers. You can choose out of data protection policy internal, data protection policy external, subject access request procedure, data retention policy, and or the data breach management procedure. So if you'd all like to do the poll now, choose your answers. We'll give you a couple of minutes there to do that, and then once again we will share the results with Stephanie and she can talk to you about it. So once again the question is, do you have any of the following policies and or procedures in place? If you could all make your answer now, please. So there we go. I'm now going to share the results with Steph. And you should be able to see those results on your screen now. Thanks, Steph.
Thank you very much, Sam. Well, that's great to see that a lot of you have got a data protection policy in place, whether it's internal or external, and actually more than I anticipated have also got data retention policies and subject access request procedures. So well done. So that leads me on to my next tip, which is policies and procedures. Now, helpfully, I've already let you do number 1. You've managed to identify what policies and procedures you have in place. Once you've completed your data map, that will also help you to consider what might need updating or what might need adding. What this will help with is your accountability principle, so that you can demonstrate to the Information Commissioner's Office that you are on board with GDPR and you are compliant. It will also help with transparency to the individuals whose data you collect, and it will help with your awareness and staff training. It's really important for the people that work with you to be able to identify data protection issues when they arise and to know what to do and who to talk to. My next tip is to nominate someone responsible in your organization to deal with data protection. So the first thing to mention is that you may not be required to have a data protection officer as a mandatory requirement under the GDPR, but if you don't satisfy those requirements, you still need to make sure somebody is on the hook and is in charge of making sure you're compliant with the GDPR. This will also form part of your policies and procedures, as well as to help with the accountability principle. Tip number 6 is to update your contracts. So I mentioned earlier that if you have any data processors, then you have to have a written contract in place, and that there are certain elements that you must include in contracts with data processors. A few of the things you have to include are the obligations and rights of each party, confirmation that your data processor will only process on the instructions from you, obviously confidentiality, and compliance with security provisions, and make sure that your data processor can't just get someone else to do the job without your consent and without making sure those obligations flow down into any further contracts. You also should address what will happen to the data at the end of the contract, because that's the thing that people often forget. Tip number 7 is to maintain a record. I did warn you that I'd talk about the accountability principle quite often, but in terms of being able to prove your compliance to the ICO if that should happen, then it's great if you've got everything kept as a record in one place. So if you keep a file of all your data protection policies, procedures, your data map, and other records together, then you'll be in a very good place should anything happen. Just to note that your data map is quite changeable and will need to be adapted and considered as the processes in your organization change. You also are required to keep records of consent separately to your other contracts if you have with schools or otherwise. Tip number 8 is data security. You'll all be familiar, I'm sure, with carrying out risk assessments, because I should imagine that that's something that happens on a daily basis in your organization. Have you considered carrying out a risk assessment of your data security? What this will do is identify areas of risk, and don't forget that they're not just areas of risk in terms of cybersecurity, but also consider things like physical security and staff. Have you got a disaster recovery plan in place, or something that you should do if there is an issue in relation to data security? And also consider how that ties in with any insurance you have in place. Staff, unfortunately, in relation to data security, are always the weakest link. So try to make sure that your staff are trained and that they are aware of what to do in the event of a security breach. Tip number 9 is to think ahead. There is a new consideration under the GDPR that makes you look at data protection issues when you're trying to implement any new systems or projects. So if you're looking at putting in place a new IT system, not only do you need to think about how much it costs, whether it's actually appropriate for the needs of your business, but you now also need to think, does it protect data adequately? And you should keep a record of those discussions and those decision-making process when you are considering new projects and systems, and put that in your data protection file to all add towards your accountability principle. And my final tip is to be transparent. As I mentioned here, the underlying theme under the GDPR is transparency. And typically, in my experience, issues only arise when people aren't sure what you're doing with their personal data. I know that the only times it frustrates me on a personal level is when I keep getting calls about whether I've had an accident in the last 3 years or if I've got a PPI claim to make. And I don't know how they've got my personal data, and I always ask them to remove me from their list. But that is when people start to make complaints, when they don't know what's happening. So make sure what you tell people at the outset when you collect their data is clear and is honest, so that there will be less issues that arise later down the line. And I'm now going to hand over to Sam to launch our final poll.
Thanks, Steph. So once again, we're going to have another poll question. I'm going to launch that now for you, so it should pop up on your screen right now. So the question is, would any of the following topics be of interest for further training or assistance? And once again, you can choose one or more. So the answers are further training on data protection matters, training on employment and HR matters, training on contracts, key risks and negotiation, training on intellectual property basics, or training on, technology jargon understood. So if you'd all like to make your answers now, and then we're going to once again share the findings from this poll question. So the question once again is, would any of the following topics be of interest for further training or assistance? And that's great. So I'm now going to close the poll. I'm going to share the results.
Great, so I've sufficiently scared you that you'd like to know a little bit more about data protection, but it's really interesting and useful, and I appreciate the participation in the poll so that we know, both us and Schools Northeast can understand what other topics would be of interest, either through their webinars or through Muckle's own events. So if we just return to our slides. You'll be really delighted to hear that we are running some accredited courses in November to help with data protection compliance. Firstly, we have an Introduction to Data Protection course, which is a 4-hour course. Then we have a Data Breach Management and Subject Access Request course. If you'd like any further details about these, please do contact data@muckle-llp.com. I've popped the dates up on the slide there for you as well so that you can tell when we're running those courses. And apart from anything else, you get a shiny little certificate if you manage to pass your short form test at the end, which you can display proudly when you head back to your organisation. So that's enough from me. I'd like to thank you all for participating as you have, and for you all for listening this afternoon, and I hope that you found the top 10 facts and top 10 tips a helpful introduction to your GDPR compliance. I'll just hand over to Sam, sorry.
It's all right, thanks Steph. So we now have time for a few questions, so thank you to anybody that has sent questions over. We've pulled a couple out for Stephanie to answer right now. All the other questions will be answered after the webinar, and we will send this out as a document to all attendees. So the first question that we've got is, do parents and/or guardians have the right to personal data about their children?
I think that's a really interesting question and comes up quite a lot with this audience actually. So there's two separate answers to this, one of which doesn't fall within data protection. But the first point is that if any of the members of our audience are at maintained schools, then there's a separate right under the Education Act for parents to have a copy of the educational records of their children. Now that doesn't mean they get all of the personal data, it's a more limited right. The next point to look at under the Data Protection Act and the GDPR is that you have to consider the age of the child in question if a parent or guardian makes a subject access request about their child. Once a child is considered an adult for data protection purposes, so when they reach at the moment the age of 12, 13, 14, depending upon their maturity levels at that stage, then in fact if a parent asks for a copy of a record, you may need to go and speak to your child. If we've got any independent schools in the audience, then this might be something you cover in your contract with the parents. The only other thing to flag in relation to access to personal data about children is that if there are any court orders in place that provide that level of access, of course you'd need to comply with those. I hope that's helpful.
That's great, thank you, Steph. So the next question that we've got is there a specific qualification to become a data protection officer?
Thanks, Sam. This question's asked quite a lot, actually. Unfortunately, the Information Commissioner's Officer hasn't taken a step off the fence to decide which courses would be sufficient to become an expert in data protection for those purposes. But there are quite a lot of providers out there who are running all sorts of different courses, and I'd be happy to share some of those suggestions if that's of interest after the webinar.
That's great. Thank you, Steph, and thank you for all your questions. As we mentioned before, any questions that we haven't answered, Stephanie will answer after today's event, and a PDF document will be sent to all attendees after today's webinar. You can also find a PDF document within the handout section on your control panel. So this document is for information about all of Schools NorthEast upcoming events. Please take the time to download this document and keep a copy for yourselves. So this year is starting to become jam-packed with events for Schools NorthEast, and here are some of the highlights. So on Monday, the 25th of September, you can join us for an Ofsted event, which is keeping up to date with short inspections, governance and SEND outcomes. There are morning and afternoon sessions available for this event. And then on Tuesday, the 26th of September, you can join us and Stephanie once again from Muckle for the GDPR for Education Organisations and Introduction to Compliance. Then on Thursday, the 12th of November, you can join us for our annual summit for 2017, where we will be celebrating Schools NorthEast's 10-year anniversary. And coming up in November is the Mock Tribunal Seminar, which is the follow-up event from last year's very popular Mock Disciplinary Seminar. You can also keep your eye out for any further webinars as our brand new and exciting webinar programme unfolds. We'll have topics specifically around SBMs, leadership, evidence-based education, governance and recruitment and retention. For more information about any upcoming events, please take a look at our website, which is www.schoolsnortheast.com/events. Alternatively, you can email info@schoolsnortheast.com with any further questions regarding anything for Schools NorthEast. So that is all the time we have for our webinar today. And once again, today was Schools NorthEast's first ever webinar. We really do appreciate any feedback, so please take a moment to fill out our short webinar exit survey. We would like to thank Stephanie and the team at Muckle for providing us with the content for today. And on behalf of Steph and all the team here at Schools NorthEast, thank you for joining us and taking the time to attend our webinar. We hope you enjoy the rest of your day. Thank you.